screen. Yeah. So today we will be looking at the treatment of crown debts or government dues under the IBC. I will take you through the brief uh, scheme of what I propose to take. So first we will look at the status prior to IBC. What was the law there prior to IBC? Then we will look at some important definitions which are required to understand how the government dues are being treated. We'll also look at some decided cases which will help us determine how the government dues are placed. And also on the impact of moratorium and how the statutory authorities' claims should be treated during moratorium. The order of priority under Section 53 in case of liquidation. So whether the secured FC versus the secured OC, how they are going to be treated. We'll also look at 11 provisions under the various other legislations and judgments pertaining to that, like the income tax, GST, customs, PF, ESI, and all these other legislations which deal with government dues. And apart from that, we will also look at how they are treated in the voluntary liquidation. And among the cases, I have tried to compile some 20 odd cases, including most of the landmark judgments that are required for us to know the treatment of the crown debts, and also try to cover the latest cases to the extent possible. So I will proceed with the first leg of the presentation, which is the status prior to IBC. Just a minute. Yeah, just give me a minute. The screen is a little slow. Yeah. So prior to IBC, we had three major legislations. We had the Companies Act, we had SURFACE, and we had the Recovery of Debts and Bankruptcy Act 1993. So among that, the first we will see the Companies Act 1956 and subsequently the Companies Act 2013. So the Companies Act primarily provides for the first priority payment to workmen dues and secured creditors. And post that, it gives the second priority of to government dues that would be pari passu with these six dues that I have set forth. So the first being wages or salary of employees not exceeding 4 months. And then it is accrued holiday remuneration payable to the employees. Then the employer's contribution payable under ESI Act. Then the compensation under the Workmen's Compensation Act. Sums due to an employee from PF, pension fund, gratuity fund, or any other fund for the welfare of employees maintained by the company. And lastly, expenses of any investigations so far as they are payable by the company. All these will be in priority payment to other classes of creditors apart from workmen dues and secured creditors. So if we see, this is similar to what we have seen under the present IBC as well, where we can see the similar kind of distribution being done. Now, if you can recall, in the Companies Act 1956, there were provisions of 529 capital A and 530 of the Companies Act 1956, which provided for this kind of a distribution. And post that, Companies Act 2013 as well provided for a similar pattern. Subsequently, IBC introduced in 2016. So apart from the Companies Act, we also had prior to IBC the SURFACE and the Recovery of Debts and Bankruptcy Act. So the securitization and reconstruction of financial assets and enforcement of Security Interest Act as the the name of the act itself suggests it covered two important aspects. One was the reconstruction of financial assets, and the second was enforcement of security interest. So this act could be uh, uh, opted for by the financial creditors or any creditor only if they had a security interest, which means if you are either a secured financial creditor or a secured operational creditor. Of course, these terms are defined only under IBC. But essentially, any creditor who is secured could take, into the SURFACE Act and enforce his security without going through the court process directly by way of issuing of notice and then selling the particular property through the auction. One mandatory requirement under SURFACE was the CERSAI registration. So the lenders had to register them and the security under the CERSAI website, which is the government website for registration. As far as the Recovery of Debts and Bankruptcy Act is concerned, so this act, what it did was it established tribunals. So we are aware of the debt recovery tribunals which were established under the RDB Act. And these tribunals started to, the banks approached these tribunals to recover their debt, and the tribunals heard and passed the orders under this particular act. So this act opened up to all types of creditors, that is being secured or unsecured. Both of them could go through the RDB Act and seek relief for non-payment of their dues. Now, what we are going to see is what is called the doctrine of election. So basically the doctrine of election says that when you have two remedies that are available for the same kind of relief, the party to whom the said remedies are available has an option to elect either of them. But this doctrine would not apply where the ambit and scope of the two remedies are essentially different. So which leads us to the question as to whether when a lender is, say, a secured lender, he has an option to go through either the IBC or the SURFACE, or he can choose to do through the Recovery of Debts Act. So which act he is going to select would depend on his choice of where he is going to get the maximum recovery. But law gives him, so the right to elect which action, which remedy he would like to take is called the doctrine of election, which again would depend on uh, which option he feels would give the maximum recovery to him. Apart from this, now as a run-up to the IBC, we have the ancestral legislative guide. So we have the Uncetral's legislative guide on insolvency law and also the BLRC report. So when we went first, when the India followed the Uncitral legislative guide on insolvency law to make its code compliant and with the international laws, the basic law that was there in the Uncitral legislative guide was that the government dues should not be given priority and they should be given a lesser priority as compared to the other dues like the secured financial creditors and the workmen dues. Why this was given, the reasoning was also given in the Uncitral guide, which said that to promote credit for the banks to have maximum amount of recovery, it is advisable that the recovery goes more to the creditors and lesser to the government. And the BLRC report, which also was the precursor to the IBC, also said that priority of payments towards crown debts should be given over secured creditors, as this hampers the recoveries made by banks in the event the debtor is being wound up. Now, why would allowing the government securities prevail over secured creditors be very important? If we allow the government dues, then what happens is it leads to uncertainty for the secured creditors regarding the sums that would be payable to them in the event of the company's insolvency. So they are not able to correctly determine what will be the recovery that they will get in case the company goes into insolvency. Why? Because the government dues are ascertained at a later date. The government comes back with their assessment notices after considerable period of time. Unlike banks or other financial institution lending where the terms are clear, and you are able to determine the quantum that is due to be payable. So depending on the asset and the quantum that is due, the secured financial creditor or any financial creditor will be able to analyze and understand what will be the sum that he would get out of the insolvency. Whereas if the government dues are given priority, then there is always an uncertainty on what he will get. The second is that it will slow down or complicate the exercise of out of court enforcement rights. And it will also substantially increase the costs of the secured creditor. Why this would complicate the out of court enforcement of right is because minute you have the priority to the government dues, the secured financial creditor, even when he is exercising his right over the property, would have to first allocate towards the government dues and only take the balance amount. And there might be some claims, counter claims against the government, which would keep going back and forth, which will ultimately increase the cost and delay the realization to the creditor. Another reason is that the cost of credit for the CD may increase because secured creditors will obviously pass on the risk of arising from the collecting the dues back to the creditor in terms of higher interest rate. So, which in the long run would not be very beneficial for the market sources and funding requirements of corporates. Another very big reason for not recommending the government dues to be paid in priority is that for the government with such a large base and tax base and collection ability, this amount due would be a minuscule amount in terms of percentage, in terms of value to the entire gamut of dues that are there to the government or the amount that it collects. So the lawmakers felt that the government would, by stepping down, the damage to the government would be very, very less as compared to some other creditor for whom this amount would be very, very significant. And it will be important for them to have this recovery in their books. Now, we'll also look at the preamble to the IBC. So the preamble to the IBC says an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner for maximization of value of assets of the such persons. So the basic objective was to one that it is a code. So obviously it combines all the laws relating to corporate persons, firms, individuals, everything into the code. And also there is an importance given on the time-bound process and also maximization of value. Why is that important? Is to promote entrepreneurship, availability of credit, and balance the interest of all the stakeholders. And the very important thing, what I have underlined in the presentation, including alteration in the order of priority of payment of government dues, and to establish the Insolvency and Bankruptcy Board of India and for matters connected therewith or incidental thereto. So what is very important here for us to note is the preamble of IBC itself says that you should alter the order of priority of payment of government dues and make it lesser significant as far as the other dues are concerned, which is the main intention of IBC. Next, we move on to some of the important definitions. So the first, we have to understand what is an operational debt and who is an operational creditor. So section 5, subsection 21, these are definitions relating to the corporate insolvency resolution process, where it says operational debt means a claim in respect of the provision of goods or services, including employment of a debt in respect of payment of dues arising under any law for the time being in force and payable to the central government, any state government, or any local authority. So here, the classification of government dues has been very clearly said that if it is under any law payable for the time being in force, and whether it is paid to the central government or state government or any local authority, it is covered under the operational debt. And then section 5, subsection 20 defines operational creditor. So operational creditor means a person to whom operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. So the assignee of a debt or a person who has taken the debt would also be classified as an operational creditor. So in the case of government dues or crown debts, they would come under the definition of operational creditor. Next, we move on to the relevant regulations of CIRP and liquidation regulations. I will first cover the corporate insolvency resolution process and then move on to the other aspects of IBC. So Regulation 7 of the CIRP regulations state that the claim by an operational creditor should be in Form B. The Regulation 17 of the liquidation regulation says that the claim of an OC should be in Form C. There has been a recent judgment saying that even if the claim has been submitted in the wrong form, the RP or the liquidator would have to compile it. And in practice, I think we do intimate the relevant creditor or the government department that the form they have submitted is wrong and they'll have to correct and submit the form. So claim can be filed only for the demand raised. That is something that we all have to note. So claim cannot be given for any demand that has not yet been assessed or raised on an ad hoc basis. This experience we have had in the case of PF authorities or ESI authorities who ad hoc compute an amount that this has not been paid by the financial credit, by the corporate debtor based on the past data. So they will assume that you have these many number of employees in the company and you were supposed to remit this amount of ESI or PF. So that we have to make sure at the time of verification of the claim that the claim is raised only for the demand that has already been raised and not for assessments that are pending. So next we move on to the next very important section, which is section 30 of the IBC, which speaks about the submission of a resolution plan. So I have just extracted the important subsections in section 30 for our understanding. So subsection 2 says that the resolution professionals shall examine each resolution plan received by him to confirm that each resolution plan A provides for the payment of insolvency resolution process costs in the manner specified by the board in priority to the payment of other debts of the corporate debtor. So on top is the payment of the CIRP cost. Subsequently, under subsection B, we have two amounts which are ranking pari passu. So it says provides for the payment of debts of operational creditors in such a manner as may be specified by the board, which shall not be less than 1. The amount to be paid to such creditors in the event of liquidation of the corporate debtor under section 53, or the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan had been distribution in accordance with the priority order of priority under subsection 1 of section 53. So section 30 leads us to the distribution under section 53 in case of a liquidation. Now, why there is an essential difference between 1 and 2 is that in certain cases, the value of the resolution plan might be more than the liquidation value, which is why maybe it is preferred by the COC. In other cases, the liquidation value may be more than the what has been offered in the resolution plan, which again the COC in its commercial wisdom may choose to approve the plan even though it is lower than the liquidation value because of its own assessment of the realization of the liquidation value or in the interest of keeping the corporate debtor as a going concern. So in both these aspects, whether it is lower or higher than the liquidation value, it has been sought that the minimum amount payable to the operation creditor should be the provided as in the in the order of priority under section 53. So whichever is higher should be provided, and provides for payment of debts of financial creditors who do not vote in favor of the resolution plan, who are the dissenting financial creditors is how the term we use, in such manner as may be specified by the board, which shall not be less than the amount paid to such creditors in accordance with subsection 1 of 53 in the event of liquidation of the corporate debtor. So the higher of the two would be what has to be paid under a resolution plan to the operational creditors. Now we move on to section 31. Section 31 speaks about the approval of a resolution plan. So if the adjudicating authority is satisfied with the resolution plan as approved by the COC under subsection 4 of section 30, meets the requirements as referred to in subsection 2 of section 30, which we just saw, it shall by order approve the resolution plan, which shall be binding on the corporate debtor, his employees, members, creditors, including the central government, any state government, or any local authority to whom the debt in respect of the payment of dues arising under any law for the time being in force, such as authorities to whom statutory dues are owed, guarantors, and other stakeholders involved in the resolution plan. So the section 31 clearly mentions that once the resolution plan is approved by the NCLT, then it will be binding not only on the corporate debtor, employees, members, and creditors, but also on the central government, state government, or any other local authority. So here itself, it is very clear that once the plan is approved, depending on what has been allocated in the plan, the government authority cannot ask for any further amounts in respect of the dues prior to the CARP. Now, we move on to section 53. 53 is providing the priority or the waterfall as per which the proceeds of the liquidation estate are to be disbursed to the shareholders. Here again, the priority to the statutory debts or the crown debts is relatively lower as compared to the previous legislations as under the Companies Act 1956 or the Companies Act 2013. So we will just quickly run through section order of priority under section 53. So the first is, as we discussed, the payment of the insolvency resolution process cost and the liquidation cost. Both are to be paid in full, followed by the following debts which shall rank equally between and among the following. So we have two debts here which are equally ranked. The first one is the workman's dues for the period of 24 months preceding the liquidation commencement date. And the second is the debts owed to a secured creditor in the event such secured creditor has relinquished his securities in the manner set out in section 52. If he has not relinquished his security, has retained, he comes lower in the waterfall. And the third one is the wages and any unpaid dues owed to employees other than workmen for a period of 12 months preceding the liquidation commencement date. Then on the fourth priority, we have financial debts owed to unsecured creditors. And the fifth priority, again, we have two debts which rank equally. One is any amount due to the central government and the state government, including amount to be received on account of the Consolidated Fund of India and the Consolidated Fund of the state, if any, in respect of whole or any part of the period 2 years preceding the liquidation commencement date. So here is where the first set of government dues comes into the picture, followed by debts owed to a secured creditor for any amount unpaid following the enforcement of security interest. So in the waterfall mechanism, if we are not able to come to the fifth category, if the amount finishes in the third or fourth category, then there will be no amount that would be paid to the government for any dues that are there. However, and that too, it is limited for a period of only 2 years preceding the liquidation commencement date. All other dues come under the sixth priority only. So the government, if at all it is taking in the fifth priority, and that too with along with the pari passu with the secured creditor who has not relinquished his security, and in spite of that, only for a period of 2 years. So this is a marked departure from the earlier laws, where the government has substantially reduced the amount that it is taking through the liquidation process. And the last is, of course, any remaining debts where the period beyond the 2 years of liquidation commencement date for the government authorities would come under the sixth priority only. I think very rare in terms of liquidation, we are able to reach the sixth level, but maybe in terms of uh, resolution plan, sometimes allocation is made to the government department as well. There was some confusion in between whether operational creditors should be treated as one category of creditors and whether discrimination can be made between the trade creditors and the government dues. All that has now become a settled law. It is possible, and we only have to go through the waterfall mechanism under 53, even in the case of resolution plan. So what is very important here is that for the creditor should decide if it is a secured creditor with security, then he has to decide whether he is going to stand outside the liquidation or he is going to give his asset for the purpose of liquidation. And if he surrenders his asset to the liquidator, then he comes higher in the priority, in the second priority. And if he chooses to keep the asset himself and sell it, then it comes in the lower fifth priority on pari passu with the government dues. So beyond that, we still have last two category under Section 53, which is the preference shareholders and the equity shareholders or partners in the case of an LLP. And any contractual arrangement between the recipients with equal ranking, if disrupting the order of priority under that subsection, shall be disregarded by the liquidator. So inter se arrangements as to the priority also has to be disregarded. This also is very important in case of the first charge, second charge, pari passu charge, so many different kinds of charges that have been filed depending on the variety. So this and there were also some discussions as to whether a person having higher security should rank better than a person who is holding a lesser value of security for the loan. So all these also have been secured settled in the court of law. Next, we move on to a very important discussion as to how we are going to say who is a secured financial creditor versus a secured operational creditor. How do they stand? So we will look at one case, which is on the Committee of Creditors of SR Steel versus Satish Kumar Gupta. That was a decision given by the Honorable Supreme Court in 2019. I will just give you a very brief background to understand how we are going to see this particular secured FC versus secured OC. So SR Steel India Limited, which is the corporate debtor, went into CIRP, and there were two resolution applicants who had shown interest initially in submitting a resolution plan. So one was ArcelorMittal and the other was New Metal. Both were found ineligible under 29 capital A of the code. So when they went and approached the Supreme Court, since the value of SR Steel was pretty high and the amount of loans that they were taken was substantial, they both approached the Supreme Court, and subsequently the Vedanta also expressed its interest in giving a resolution plan. So what the Honorable Supreme Court did is it gave another chance to both ArcelorMittal and to New Metal to set right their default under Section 29A and again submit the resolution plan. It was a second life given. So quickly what happened was Arcelor went and paid off their NPAs and then resubmitted the plan, which was in that plan, the allocation to the various creditors was left to the discretion of the COC. What the COC did was it allocated all the amount to the secured FCs, except Standard Chartered Bank. The reason why they said Standard Chartered Bank is not being allocated is because Standard Chartered Bank was not a direct lender to SR but it was in the stage of a guarantee which had been given by SR Steel for a loan taken by one of its foreign subsidiaries. So since it was not a direct lender, the COC decided that they should go in for the uh, distribution to all other creditors alone. When the matter reached NCLAT unilaterally altered the distribution schedule, where it gave a sweeping judgment which says that all creditors, secured, unsecured, OCs, everybody should be treated at par. This was what had come before the NCLAT. So NCLAT laid down what is called an equality principle down the board, where what it said is whether creditors are secured or unsecured, financial or operational, equitable treatment demands that they are all treated as one group of creditors. And as a result, no difference can be made in the terms of amount of debt to be repaid to them, whether on the basis of whether they are secured or unsecured, or whether they are financial or operational creditors. So this came as a big blow to the uh, entire IBC, who were dealing with IBC. And subsequently, what happened was the government went ahead and passed the IBC Amendment Act 2019 with retrospective effect, which said that only minimum payment should be given to the OCs and in terms of liquidation, and dissenting financial creditors also should be given the liquidation value. Now, when the matter went before the Honorable Supreme Court, because all the creditors were very unhappy because their realizations had come down to less than 66% because of the decision of the Honorable NCLAT, they went to before the Supreme Court. The Supreme Court had observed that if equality for all approach is adopted, then the secured financial creditors in many cases be incentivized to vote for liquidation rather than resolution, as they would have better rights if the CD was liquidated rather than in resolution, which would ultimately defeat the very purpose of the court, and where which said that first you should ensure resolution of distressed asset, and only when it is not possible you have to go in for liquidation. So the Honorable Supreme Court felt that the FCs and OCs can never be placed equally. However, in between, when the Supreme matter was before the Supreme Court, the IBC Amendment Act was passed. So with retrospective effect, so that is what we have in effect now. So Section 30, subsection 2, which we already saw, that will be the priority as what stands now. Next, we move on to the initiation of CIRP. So once the CIRP is initiated, the tax authorities who are being an operational creditor can also should submit their claim. Apart from submitting their claim, they can also initiate CIRP under Section 9, being an operational creditor. They'll have to follow the same process of giving a demand notice. The probability is that once the demand notice is issued, the CD may pay their dues, but mostly the statutory authorities would not prefer to go down this line because of their own internal approval constraints, and also given the fact that they have to uh, bear the first month's CIRP cost, which would be very uncertain, and it will be difficult for any government authority to get this approval done. So they will not be able to go through this, but they may participate if somebody else has the uh, initiated the CIRP. Now we look at moratorium. So once the the CD's application or the OC's or FC's application is admitted and the company goes into CIRP, moratorium sets in immediately, and a claim has to be given by the OC. We will just look at one of the early cases in 2017 before the Honorable NCLAT, which is the Director General of Income Tax and another versus Synergy Dorai Automotive Limited and others. where the NCLAT considered whether income tax, value-added tax, or other statutory dues, such as municipal tax, excise duty, etc., come within the meaning of operational debt, and whether central government, state government, or any other legal authority having statutory claim come within the meaning of operational creditor. So this was what was before the Honorable NCLAT, and the Honorable NCLAT held that the operational debt in normal course means a debt arising during the operation of a CD. So what happens is when a CD is operational, it is being considered as a going concern. Obviously, statutory liabilities arise, such as income tax, value-added tax. So depending on what activity the company is carrying on. And since they all are this income tax and value added tax and other statutory dues arise out of the existing law, when the CD is operational, such statutory dues have direct nexus with the operation of the CD. This was the observation of the Honorable NCLAT. Therefore, all statutory dues, including income tax, VAT, etc., come within the meaning of the operational debt. So it also clarified consequently that income tax department of the central government and sales tax department of the state government and a local authority who are entitled to dues out of the existing laws are all operational creditors. So this clarity was clearly given by Honorable NCLAT. There's one that the imposition of moratorium does not prevent the tax assessments from taking place. What it does prevent is the execution of any judgment or order. So the assessments, the hearings, everything can go through during the moratorium. However, the final order or the execution of order alone would be kept on hold pending the decision of the CARP. And any action to recover is prohibited during the moratorium period. What happens if the government authority contravenes this moratorium? The penalty is provided under Section 74 of the IBC. We will just briefly look at Section 74, which is punishment for contravention of moratorium or the resolution plan. So, where a creditor violates the provisions of Section 14, any person who knowingly and willfully authorized or permitted such contravention by a creditor shall be punishable with imprisonment for a term which shall not be less than 1 year, but may extend to 5 years, or with a fine which shall not be less than 1 lakh, but which may extend to 1 crore, or with both. So there is a severe punishment given here for violation of Section 14, which would be the person who is signing the order or the authorized person who has been willfully contravening the moratorium. He will be subjected to imprisonment for not less than 1 year up to 5 years, and also with uh, fine of 1 lakh, which may extend to 1 crore. There is quite a huge penalty levied in case of contravention of the moratorium. So the government departments have to be educated, showing all these provisions that they are not entitled to pass any order or initiate any recovery during the moratorium period. Now, next we come to the Committee of Creditors. In the Committee of Creditors, the OCs will also form part of the Committee of Creditors in case there is no financial creditor. There are three different voting limits prescribed under the COC meetings. One is the 51%, that is a simple, more than 50, that's a simple majority. Apart from that, we have a 66% voting for the purpose of resolution plan and 90% voting in case of withdrawal under Section 12 capital A. Now, the Section 24(3)(c) gives the right of all the OCs to attend the COC meetings if the aggregate dues are not less than 10% of the total debt or claim. So here the RP will have to invite for the claims, and then after they have seen whether there is any particular OC class which is more than 10%, then they have to invite them to attend the COC meeting. One more case is where the committee does not have any financial creditor, then the committee will have to be formed only of operational creditors. One more case would be if all the financial creditors are related to the corporate debtor, there again the committee will be created only by the operational creditors. So the 18 largest OCs by value would be called to convene to form the committee of creditors, and their voting rights would be in proportion to the debt due by such creditor. So you have to, the government department also has a right to come to the committee of creditors if they satisfied either the 10% criteria or if one of the financial creditors are there to form the COC. Next is on the verification of claims. So the first what has to be checked is whether the claim is in the correct form. If it is not in the correct form also, RP can collate the claim and inform the respective authority to resubmit the claim in the correct format. And then we have to check whether the authority of the officer signing the claim form is there by way of any order or any internal communication which they will have to provide to say that they have the authority to submit the claim. Then all necessary enclosures to support the claim should be there, like the assessment order, the appeal order, the recovery certificate, the statement of account. And if there are any refunds, the refund should be adjusted from the claim amount. The IRP or RP should cross-verify these from the records of the corporate debtor as well to the extent available, or they can also access it from the respective tax websites where most of the tax returns are now filed online. Apart from that, you have to be aware of the Limitation Act. So in normal circumstances, the limitation period is 3 years, whereas for the purpose of crown debts, that's the government dues, the limit is 30 years. So the government can come back without any the limitation period of 30 years to claim the dues. And the claim should be to the period prior to CIRP. If it is during CIRP and post approval of the liquidation plan, the treatment would be different. So if it is for the CIRP, when you are admitting the claim to the period up to the insolvency commencement date. Similarly, if it is a claim during liquidation, then up to the liquidation commencement date, that is what has to be admitted as the claim. So the powers and duties of a resolution professional. So as soon as the resolution professional takes control, they immediately have to give a public announcement. Most of the government authorities do not keep track of these public announcements, though recently they are keeping track to some extent. But majority of them do not keep track. There is too many divisions and circles and departments for them to keep track as to which fall under their particular jurisdiction. So it becomes imperative on the IRP to immediately intimate all the statutory authorities. So what can be done is we can take all the registrations that the company has taken, make a list of those and intimate all the relevant statutory authorities. To some extent, we will also know, depending on the business in which the particular CD is engaged in, we will have an idea as to what are all the authorities that have to be intimated. Apart from that, from the books of records and other relevant documents with the government authorities also can be accessed by the IRP or RP. They have to take immediate control and custody of the asset which the CD has ownership right. In certain cases, the CD may not be having possession of their own assets. Basically, in case of any attachment or possession by the statutory authority, so the authorities would have to be immediately intimated and the possession should be taken by the IRP or RP. And in case they are not cooperating, including government authorities, if they are not cooperating in providing the information or giving access to the IRP or RP, they can approach the NCLT to seek directions. Apart from this, the RP is responsible for complying with all the laws applicable to the CD, which would include TDS, TCS, payment of income tax, GST, regular filing of returns. What we have not missed out is PF, ESI if it is a going concern. So all the statutory payments have to be ensured by the RP. And in case no claim is received, then what should the RP do? There is a guidance on that as well. It says take the available information from the CD, from all the websites of the government departments, and include that in the information memorandum so that the prospective resolution applicants are aware of what is the government dues that are there to be paid by the company. So the best estimate would have to be done, and maybe wherever estimate is not possible, the RP can make some kind of estimate and update the information memorandum once further information is received. Next, we look at some of the important landmark judgments in case of government dues. So so the first case we will look at is Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company. It was decided by the Honorable Supreme Court in 2021. So what was held in major in this particular case is that once the resolution plan is approved by the COC, the claims as provided in the plan shall stand frozen. It will be binding on the corporate debtor, its employees, members, creditors, including the central government, any state government or any local authority, guarantors or other stakeholders. They have reproduced what is there in the code. On the date of approval of the resolution plan, all claims which are not part of the resolution plan shall stand extinguished. So here it is very clear in case anybody has not submitted their claim, it should be stand extinguished and no proceedings in respect of such dues for a period prior to the date on which the AA grants its approval under section 31 would be continued. So there is an embargo on the continuation of the proceedings prior to the, which have initiated prior to the uh, commencement of the insolvency process. So two very important things we will have to note here, that one is the claims have stand frozen, and secondly is that which are not part of the resolution plan stands extinguished on the date of approval of the resolution plan, something what we call the clean slate theory. The next very important landmark judgment in terms of the government dues is that of the Rainbow Papers, which was the judgment delivered by the Honorable Supreme Court on the 6th of September 2022. So here, the one very important question that was placed before the Honorable Supreme Court is whether the provisions of IBC, in particular Section 53, override Section 48 of the GVAT Act of 2003. So the Gujarat value added tax was what was under consideration before the Honorable Supreme Court. The state tax officer had filed this appeal before the Supreme Court. Let us first look at Section 48 of the GVAT Act, which says the tax to be a first charge on property. So it starts with a non-obstante clause, notwithstanding anything to the contrary contained in any law for the time being in force. Any amount payable by a dealer or any other person on account of tax, interest, or penalty for which he is liable to pay to the government shall be a first charge on the property of such dealer, or as the case may be, such person. So that starts with a non-obstante clause. The act was passed in 2003, much prior to the passing of the IBC. And it also said that notwithstanding anything contrary contained in any other law, which is very important for us to note, any amount payable by a dealer on account of any tax or interest or penalty, so it covers everything, it covers tax, interest and penalty, that is any damages or any penalty that is leviable by the government, will be a first charge on the property of the dealer. So he has given the first right to that of the state tax officer. So what happened in Rainbow, I will just give a brief flow of events for us to understand because it's one of the landmark judgments. Immediately after this order came, IBBA also was kind enough to give a summary of all the major decisions and circulate it to all the IPs. So the flow of events is like this. First, on 8th of July 2016, the recovery proceedings were initiated by the state tax officer. On 12th of September 2017, that's nearly a year after that, the corporate debtor was admitted to CIRP. On the 22nd September of 2017, IRP was appointed. In June 2018, a resolution plan was approved. After the approval of the resolution plan, on the 8th of October of 2018, the property was attached by the state tax officer, and the claim was also filed by him beyond the time after the approval of the resolution plan. And after the resolution plan was approved and he submitted his claim, the state tax officer called for the RP and asked what was the amount that was allocated to the department in the resolution plan, to which the RP replied there was no claim, nothing was allocated in the resolution plan. So on the 20th of December 2018, the state tax officer challenged the resolution plan where he said the entire claim was waived off without giving him any opportunity to look at the resolution plan. And on 27th February 2019, NCLT Ahmedabad rejected the application as not maintainable. So we have seen the flow of nearly 3 years from the time the recovery proceedings were initiated to the time NCLT Ahmedabad has rejected the application of the state tax officer. Subsequently, he filed an appeal before the Honorable NCLAT, and on 8th of April 2019, the appeal before NCLAT was also dismissed, and the allocation in the resolution plan was upheld. Again, the matter reached the Supreme Court, and the Honorable Supreme Court examined both IBC and the regulations. And the timelines in IBC, it was said that the 180 timeline or the 14 days timeline to admit the application, all these were directory and not mandatory. And one of the sweeping judgments in this orders was that no obligation on the state to lodge a claim with respect to dues which are statutory, for which recovery proceedings were also initiated. So we have to remember that this regulation 12(1) of the CARP regulations, this was amended with effect from 4th of July 2018, where instead of the words proof of claim, the words claim was replaced. So prior to that, the stand taken by the Honorable Supreme Court was that only proof of claim had to be submitted by the government authorities, and hence the claim itself should have been noted by the IRP, and therefore it should have taken cognizance of the claim, especially when the recovery proceedings were initiated and it was in the knowledge of the IRP and RP. Subsequently, of course, once the regulation 12 has amended, it is now mandatory for the government departments to now submit a claim. Rainbow judgment was to the prior period where this regulation was not amended. Now we look at some important paragraphs which I have extracted from the order. Paragraph 55 of the order, it says, in our considered view, the NCLAT clearly erred in its observation that 53 of IBC overrides section 48 of the GVAT Act. So section 53 of IBC also begins with a non-obstante clause, which says that notwithstanding anything contrary contained in any law enacted by the Parliament or any state legislature for the time being in force, the proceeds from sale of liquidation of assets shall be distribution in the following order of priority, which we have already seen earlier. So the court observed section 53 also begins with a non-obstante or similar to section 48 of the GVAT Act. Further, it said section 48 of the GVAT Act is not contrary or inconsistent with section 53 or any of the provisions of the IBC. Says that under section 53 1B2, debts owed to a secured creditor, which would include the state under the GVAT Act, are to rank equally with other specified debts, including debts on account of workmen dues for a period of 24 months preceding the liquidation commencement date. So the secured creditor was the word that has been used in section 53. which the Honorable Supreme Court said is not inconsistent or contrary to Section 48. Whereas Section 48, you have to read that it is that state is a secured creditor as per the provisions of the law itself. Further, this, so this is what it is observed. As observed above, the state is a secured creditor under the GVAT Act, and under Section 330 of IBC defines secured creditor to mean a creditor in whose favor the security interest has been created. So, such security interest need not be necessarily be created by the agreement between the parties. It can also be created by the operation of law. And further, the definition of the secured creditor does not exclude any government or governmental authorities. This was also an observation of the court, and therefore the court concluded that it is possible for the state tax officer to claim the amount as a secured creditor in priority under Section 53. Against this order of the Rainbow Jar Papers order, 5 review petitions were filed before the Honorable Supreme Court. There were 2 people who were not actual parties before the initial civil appeal who also filed the review petition. One was the liquidator of Biotor Industries, who is also a registered dealer under the GVAT Act of 2003. He claimed the review petition. He filed a review petition claiming to be an aggrieved person. So he was also a dealer under GVAT. So it would have affected him also directly. That is why he filed a review petition. Similarly, SBI, who was one of the consortium of lenders to Biotor Industries, also filed a review petition in the same matter. So the court first took note that even third parties who consider themselves to be an aggrieved person may take recourse to a remedy of the review petition. It is not necessarily that you should be a party to the original civil appeal. This was one of the important what I wanted to bring it to your attention. The court also referred to in the review petition to Parsian Devi and others versus Sumitri Devi and others. This was a judgment given by the Honorable Supreme Court in the year 1997, which read about Order 47, Rule 1 of CPC, where it is said that it is not permissible for an erroneous decision to be reheard and corrected. The review petition has a limited purpose and cannot allow to be an appeal in disguise. So when the matter reaches the Supreme Court, it is supposed to reach finality, and you cannot go in for an appeal towards the review by way of a review petition. It can only be to any limited purpose of any correction that can be made through the review. So the final review order was given on the 31st of October 2023, where it said that the petitioners have failed to make out any mistake or error on the face of record in the judgment and have failed to bring the case within the parameters laid down by this court in various decisions for reviewing the impact judgment. Therefore, the review petitions were dismissed. So, in effect, the rainbow paper judgment stays, except for the fact that the review petition limited it to this particular matter, and thereafter none of the other matters were there. What gave relief to the government department subsequently was, sorry, to the financial creditor subsequently was this Paschimachal Vidyut Vitran Nigam Limited versus Raman Ispat Private Limited, which was again an order of the Honorable Supreme Court on 17th of July 2023, which kind of diluted the rainbow judgment further. So we'll run through the facts of this case. The CD entered into an agreement with this Paschimachal Vidyut Vitran Nigam for supply of electricity on the 11th of February 2010, which provided that outstanding electricity dues will constitute a charge on its assets. The clause 8 of the agreement that was entered into for supply of electricity also mentioned that the parties will be governed by the 2003 Act, that is the Electricity Act of 2003. So this PPVNL started raising bills for supply of electricity to the corporate debtor from time to time. And when the dues remained unpaid, PVVNL attached the CD's properties by order dated 12th of January 2016. So the agreement was in place from 2010. Subsequently, when the dues increased in 2016, they attached the CD's property in by way of an order. So the CD underwent a resolution process initially, but the process could not succeed. They were not able to get a resolution applicant and a plan. So therefore, it went into liquidation. Now, the PVVNL's arguments were that this being a special law relating to all aspects of electricity, that is, Electricity Act 2003, covered everything right from the generation to the transmission to distribution to adjudication of disputes. It had primacy over all other laws, including that of IBC, which was a general law leading with corporate insolvency implemented much later. So they invoked the provisions of interpretation, which said that the special act should always be given more priority than a general law. And also they said while dealing with the interplay between Electricity Act and the IBC, 238 of the IBC overrides provisions of Electricity Act, both containing similar provisions in terms of both had non-obstante clauses, that is section 173 and 174 of the Electricity Act, as well as section 238 of the IBC. So the Supreme Court here is where we said Rainbow Papers did not notice the waterfall mechanism under section 53. The provision had not been adverted to or extracted in the judgment. Which the GVAT Act creates a first charge in favor of the state, a separate and distinct treatment of amounts payable to secured creditor on the one hand and dues payable to the government on the other hand under the waterfall mechanism under section 53 clearly signifies Parliament's intention to treat the latter differently. It's very, therefore, in the present case, having lower priority, it is also evident from the preamble to the IBC. So this court has clearly clarified in the PVVNL judgment that the Rainbow Papers did not notice the waterfall mechanism under section 53, and there is a separate distinction between government dues and secured creditors, and therefore only secured creditors would fall under the priority under section 53 and the government dues would come down and the Rainbow Papers has to be confined to the facts of that case alone. The Supreme Court also dealt with one more issue, which is Section 77 of the Companies Act. So Section 77(3) of the Companies Act says, again with the non-obstante clause, notwithstanding anything contained in any law for the time being in force, no charge created by a company shall be taken into account by the liquidator or any other creditor unless it is duly registered under subsection 1 and a certificate of registration of such charge is given by the registrar under subsection 2. Therefore, there is two requirements that have been given under section 77. In case the corporate debtor is a company, the charge would have to be, cannot be taken into account by the liquidator unless it is registered and a certificate of registration has been given by the registrar of companies. Therefore, this again, section 77 is only for the purpose of the liquidator, not under the CIRP process. Under the CIRP process, per se, there is no distinction in terms of the committee of creditors, whether they are secured or unsecured. There are only distinction between financial creditors and operational creditors. Whereas it comes under importance when you come to the distribution under a resolution plan or a distribution under liquidation. So therefore, the court concluded that in the court's opinion, the liquidator cannot urge this aspect at this stage because of the concurrent findings of NCLT and the NCLAT that PVVNL is a secured creditor. So what RP should look out for is they have to examine the relevant legislation to see whether the charge is created in favor of the statutory authority. We'll have to look at the language and intent of the legislation. So therefore, there is no requirement of an agreement to be entered into for creation of charge in favor of a statutory authority. And we also have to examine whether the governing legislation has any provision relating to IBC. How the claim has been submitted is also a very important aspect. Whether while submitting the claim, the government department has declared that it has a charge over the property, or there is any existing, attachment over the properties, or any prior action or notice that the government department has provided. All these have to be looked out for by the RP. Very important to see the state legislations wherever it is applicable to the corporate data, and also read the language of those particular legislation to see whether the statutory authority exercises any charge over the assets of the corporate data. If there is no such provision, then there would be an unsecured government due only, which will come lower in the priority. However, like in the case of the Gujarat value added tax, if they are having the right to attach the property, they do get first charge over the property, which means they will be treated as a secured creditor higher up in the uh, matrix, waterfall mechanism. Now we will look at individually each of the tax laws and other government claims and see whether how they are treated under the various provisions of the particular act, and also in terms of the orders that have been issued by the Honorable NCLT, LAT, and the Supreme Court. First, we will take up the very important tax law being the Income Tax Act. So the RP or the liquidator is responsible for deducting and remitting the TDS and TCS and filing of returns. So during the CIRP and the liquidation period, the RP would be doing that. And Section 178 of the Income Tax Act says the liquidator should notify the assessing officer immediately on liquidation order being passed. However, there is a specific exemption under Section 178 to companies undergoing liquidation, where it says that the prior approval of the income tax department before the sale of assets is not required. The tax law has been amended to take cognizance of the IBC. And Section 46 of the Income Tax Act, which says capital gains on distribution of assets under liquidation will not be regarded as a transfer under Section 45. Then Section 288 of the Income Tax Act, which says that the RP or the liquidator can appear before the income tax authorities as an authorized representative in case of any notice or any kind of tax dispute or demand or any kind of hearing. The RP and liquidator can appear either in person or can authorize somebody through a power of attorney or authorization. Then Section 140 of the Income Tax Act, where verification of return of income can be authorized by the RP or liquidator. Section 238, subsection 2 says the right of the liquidator to claim refunds from the income tax department. So what happens is sometimes there is a lot of refunds that is due to the corporate debtor, and those refunds may help in the easing the cash flow, the immediate meeting of the CIRP expenses or liquidation expenses. Therefore, there is a right given to the liquidator to approach the department to release all the uh, pending refunds to ease the cash flow of the corporate debtor. So these are the main provisions of the Income Tax Act, which is relevant to the government dues. Now we will look at some of the decided cases. The first is our Pooja Bahari, the liquidator of Shriram Line Products Private Limited versus G Ispat Private Limited. That was before the NCLT of New Delhi. So here the liquidator had sold the assets in auction, and there was a doubt whether the capital gains tax will be attracted on the sale of secured assets and whether that would form part of the liquidation cost. If the capital gains was attracted and it forms part of the liquidation cost, it comes under the first priority, and the department would have to be paid prior to distribution of any other any other secured creditor and workmen. Whereas if it had to be treated as a government due, it would come with the lower the priority. So the liquidator did not know how to classify this. So she rightly approached the Honorable NCLT seeking directions under 60 subsection 5. And it was also discussed the applicability of Section 178 and 194 IA of the Income Tax Act will not have overriding effect on the waterfall mechanism under Section 53. So 194 IA provides that wherever the property is being purchased, the purchaser will have to deduct 1% tax at source and remit the same. So the applicability of both 178 and 194 IA was said to not to have overriding effect over the waterfall mechanism. And the capital gains would be paid only as an operational debt, and that too only if assets are available for distribution to operational creditors. So the direction given by NCLT New Delhi was here very clear. So the whatever amount was sold in auction was available for distribution as per the waterfall mechanism, and the capital gains tax had to be calculated and added to the operational debt payable to the income tax department. In case in the waterfall mechanism down the line in the fourth priority, if any amount is left, that would be paid to the income tax department. The next case is on Leo Edibles and Fats Limited versus the Tax Recovery Officer. This is an Andhra Pradesh High Court order given on the 26th of July 2018. So what happened is the company here bought out this corporate debtor through the CARP process, and after that, when they went in to register the company, the sub-register refuses to register the purchase of the removable property in liquidation proceedings, saying that the IT department had a claim over the charge of the property purchased to the attachment proceedings. So the court held that the IT department cannot claim the property merely because of the fact that there is an order of attachment long before the initiation of the CARP proceedings, which itself means even if there is an order of attachment and the buyer has genuinely bought the proceedings in auction under liquidation, he gets priority instead of the income tax department, which comes lower in the priority. What has to be done is income tax department would have had to file a claim with the liquidator, and the liquidator will distribute the amount. But the income tax department cannot stop the transfer of the property. So the matter went before the Andhra Pradesh High Court, and there section 36(3)(b) of the code was examined, where it said that liquidation estate assets may or may not be in the possession of the CD, but including not limited to encumbered assets. Order of attachment therefore cannot be taken as a bar for completion of sale effected by the liquidator under the provisions of the code. The IT department has to submit the claim to the liquidator for consideration, and the liquidator will accordingly distribute in the waterfall mechanism. The writ petition was allowed, and the sub-registrar was ordered to entertain and register the sale transaction. So in case any government department, any registration issues are there, this particular matter can be referred to. You will have to file a writ petition before the High Court and get the orders for the sub-registrar to register. Move on to one more matter. Principal Commissioner of Income Tax versus C. Ramasubramania, RP of Surana Corporation. This is an NCLAT judgment on the 13th of December 2019. Says that even if the IT department was construed to be a secured creditor as per the provisions of the IT Act, it cannot be claimed. It cannot be claimed as a secured creditor under the code, and there is no provision in the CARP regulations for OCs to claim that the CD had created a security interest, while there is such provision in favor of the FCs. So here, in the particular NCLAT has clarified in 2019 that under the provisions of the Income Tax Act, even if the Income Tax Department is claimed to be a secured creditor, under the CARP or under the IBC code, it cannot be treated as a secured creditor. It will be only treated as operational credit, unsecured operational creditor. One more case, Income Tax Department versus G. Madhusudan Rao, RP. This is by the Honorable NCLAT. So it was submitted that the IT department, it was a secured operational creditor, and therefore it was entitled to the benefit of the rainbow judgment. The NCLAT held that the rainbow judgment was to be a secured creditor on the basis of the relevant statutory provisions. And in the case of the Income Tax Act, there was no statutory provision to prove that the Income Tax Department is a secured operational creditor. There again, the Act was clearly examined. So the only GVAT Act was found to have a sweeping provisions which said that charge would be created by way of a legislation itself, first charge. Whereas in the income tax department, the court has observed that such charge is not available, such provision is not available. Therefore, IBC will only prevail and income tax department will be treated as an unsecured operational creditor only. There's one more case. I pulled out a lot of cases in the income tax department because there has been quite a bit of confusion and tax laws are very difficult to handle. So this tax deducted at source is not a tax demand. This is the case in the case of Om Prakash Agarwal versus Chief Commissioner of Income Tax TDS by the NCLT in New Delhi. So it says that wherever a sale price comes to the liquidator, it comes only after deduction of TDS. So where is the question of IT authority standing in queue for realization of TDS? Deduction of tax at source shall not be construed as a tax demand. That was what was held by the Honorable NCLT New Delhi. Moving on to one more case in the case of Vasan Healthcare versus Deputy Director of Income Tax Investigation. This is before the Honorable High Court of Madras, a recent judgment last month, 9th of January 2024. So here, Vasan Healthcare, the corporate debtor was under corporate insolvency resolution process. There was a successful resolution applicant who took over the management of the corporate debtor. And the resolution plan was approved on 1st of April 2023. The CD and the erstwhile directors were prosecuted by the Income Tax Department for offense under the Income Tax Act that was committed during the various assessment years right from 2010-11 to 2015-16. Just to give a background here, there was one of the promoters of Vasan Healthcare. During the course of this AARP, he also passed away. But there were some criminal cases pending against the MD, the then MD of the CD, and also against some of the other officials of the corporate data, as well as the corporate data itself. So the writ petition was filed before the Honorable High Court of Madras to squash the petitions that were filed against the new management, saying that as per section 32A of the IBC, the liability of the corporate debtor gets completely wiped off after the resolution plan is approved by the NCLT, and therefore prosecution against the CD cannot be continued, especially for the period prior to the uh, resolution plan approval date. So these were the orders of I've extracted the relevant portions of the order of the Honorable High Court of Madras. So it says that once the resolution plan is accepted by the NCLT and orders are passed, the CD gets into the hands of the new management. And therefore, all past liabilities, including criminal liability of the CD, gets wiped off and the new management takes over the company with the clean slate. The clean slate theory we saw earlier also. The only confusion was whether past liabilities also include the criminal liability, because there was always a confusion whether only the civil laws extinguishment was covered or whether criminal liability was also covered. So the court held that the criminal liability of a company cannot be transferred to another company or through the new management ipso facto. Therefore, the continuation of criminal proceedings against the CD can no longer subsist. They also said it is left open to the respondent to identify persons who are in charge of running the company and who are involved in the day-to-day affairs of the company during the relevant point of time. And it will be left open to the respondent to continue the criminal prosecution against those officers. Therefore, by order of the Honorable Madras High Court, the continuation of criminal proceedings under the uh, new management of the corporate debtor was stopped, and only against those persons who were responsible it was allowed to be continued. Clean slate theory was applied. We come to the last case which I have combined under the Income Tax Act. So Vinod Kumar Kotari, the liquidator of NISCO Corporation versus IT Department, passed by the Honorable NCLT Kolkata this month. That's the 1st of February 2024 order. So the IA was filed for refunding the full amount of about 54 lakhs in the liquidation account of the corporate debtor, which was wrongfully adjusted against purported tax dues of the corporate debtor. So in the order, the NCLT Kolkata held that the income tax department may have a claim against the corporate debtor, but this would fall under the category of an operational creditor and would have to file a claim before the resolution professional or liquidator, and the liquidator with the liquidator to recover their dues in the requisite form. It was so therefore their unilateral action of adjusting the refund amount against the claim was not allowed. It said that the refund of income tax falls under the asset of the corporate debtor and would be added to the liquidation asset. Under the scheme of the code, the creditors, in this case the income tax department, are not empowered to set off the returns of the corporate debtor, which fell within the liquidation period against the past dues. Sorry, it should be read as refunds. Thus, it is clear that the code overrides the Income Tax Act insofar as the present case is concerned, and hence the adjustment of income tax refunds during the liquidation period, which is an asset of the corporate debtor in pursuance of the IT Act, is void. Therefore, the court directed the respondents to refund the amount of 54 lakhs to the liquidator within 2 weeks from the date of the order. Therefore, if there is any amount that is due as income tax refund in the books of the corporate debtor, or if it is so determined from the income tax department, it is important for the RP or the liquidator to quickly approach the department citing this case and take the refund independently without it being adjusted with the claims. Failing which, you can approach the Honorable NCLT for necessary directions similar to this. So with this, we have done with the Income Tax Act. We will move on to cases under the GST Act. So GST is payable on transfer of the movable assets,
Madam,
whereas,
can I ask one doubt?
yes, sir, please.
Madam, now my confusion is that is the Rainbow case or the Raman case, which is supreme now? Is both same or
The,
for a
the Raman
government debt
case, yes, sir.
is the final? Raman case is the final, so government debt is last priority.
Sir, you will have to see the relevant act. That is what I said. If you take Income Tax Act, then it will be
It
treated
is
as the
okay,
government due
last.
lower priority.
I'm talking the
Similarly,
old sales tax acts of each state
each
government.
state you will have to examine, sir. The Gujarat Sales Tax Act still has priority because the law
Okay,
still holds good.
I
Other
think in
than
every
that, all
state,
the laws.
I think in
Yes, sir.
every state that is the issue. I think the old VAT acts are showing it as
Yes,
first charge.
yes, sir. So we'll have
So
to examine if you are coming under the VAT dues under the VAT Act, then
it
the
will be first
respective state
charge.
VAT, it will be first charge.
Okay, okay.
Whereas
Thank
if
you.
you come under welcome.
Understood,
G,
understood.
yes,
Thank you, thank you.
yes. So when it comes to GST, the sale of a business or part as a going concern is not taxable. There is a clear notification in 2017 to that effect. Only if it is on movable assets, then GST is liable to be paid. Now we will look at some of the cases in this. One of the landmark judgments here again is the Jet Airways judgment given by the Honorable NCLAT in 21st of October 2022. So, NCLAT, while dealing with the issue of whether the Department of State Tax can be treated as secured creditor for the purpose of IBC pursuant to provisions of Section 82 of the Maharashtra GST Act. So, here it is analyzed the Maharashtra GST Act of 2017, which is enacted after the IBC. So, Section 82 of the Maharashtra GST Act says tax to be a first charge on property. Here again, it starts with a non-obstante clause, notwithstanding anything to the contrary contained in any law for the time being force. Here it says, save as otherwise provided under the IBC. So here there is a specific exemption given to the IBC. Any amount payable by a taxable person or by any other person on account of tax interest penalty, which is he is liable to pay to the government, shall be first charge on the property of such taxable person or such person. So here again, similar wordings as in the GVAT Act. Only difference is it excludes save as otherwise provided under the IBC. So the NCLAT has held the provisions of Section 82 of the Maharashtra GST Act contains an exception with regard to IBC, and therefore, on the strength of views of the Maharashtra GST Act, no charge can be claimed on the assets of the corporate debtor. The ratio laid in rainbow papers will not be applicable to the dues under the Maharashtra GST Act in view of the specific exclusion of IBC under Section 82. It's clear,
Ma'am,
sir. This is how
is it because the Jet Airways people, it is a very classic case and is an abuse of the IBC, 8,500 crores and 350 settlement, because they are so powerful, they got it like that. Is it so?
Not necessarily, sir. If we independently look at the act per se itself, there is a specific exclusion to IBC. So there is a clear demarcation how they have treated GVACT Act and how they have seen the Maharashtra GST Act. I think when there is an act is giving a specific exclusion, I think court has analyzed that and given the order accordingly.
No comments on that actually, but I find that the Jet Airways in all cases has employees and everyone, and they escaped. That's it.
Sir, even now they are not able to pay. The resolution applicant is
Exactly.
suffering. So
Exactly,
it is
that's true. They appointed the global Grant Thornton and like that actually.
yes.
Anyway, go on please.
Yes. So the next we will look at the Assistant Commissioner of Commercial Taxes versus Alok Kailash Saxena. This is one of the matters before NCLAT again, where the NCLAT relied on the PVVNL judgment to hold that the claim under Section 82 of the Karnataka Goods and Services Tax would not constitute first charge at par with the secured creditors due to the specific exemption provided under Section 82 of the Karnataka Goods and Service Tax Act, similar to what the 82 of the Maharashtra GST Act that we had seen earlier. So on the GST Acts, I think all states are clear that you have to, it will not be given priority. Rainbow will not hold good, but PVVNL judgment would hold good. We want to know one more case where the Kerala State GST Department versus NCLT. This is before the Honorable High Court of Kerala. Again, a very recent judgment on the 30th of January 2024. I will run you through the facts of the case. So this Albana Engineering India Private Limited is the corporate debtor who was admitted to CARP on the 25th of October 2019. And a moratorium was declared against the CD on admission into CARP. And subsequently, on the 2nd of December 2021, the liquidation order was passed. So as we are aware, the moratorium under Section 14 comes to an end and Section 33 continues. So a notice was issued under 25(1) of the Kerala VAT Act to the CD for a period of 20 pertaining to 2015-2016. And the assessment for the year 2015-16 was completed in 25 to 2021. That is during the period of CARP when the moratorium existed. And the total liability was assessed at around 11 crores. So what the department did when the liquidation was announced, they filed the claim before the liquidator around 11 crores is what they filed. Now, against that, the liquidator filed an application before NCLT Kochi bench under 33(5) seeking to file an appeal against the order of the assessment. Now, though the application filed by the liquidator was only to file, an permission to file an appeal, NCLT said this order of passing the order during CARP itself is a violation of Section 14(1)(a), and therefore what it did, it declared the assessment order itself void ab initio. And the NCLT dismissed the application and directed the liquidator to consider the claim independently with ignoring the assessment order of 25 to 2021. So here the NCLT did not invoke the penalty provisions of Section 74, but instead they just declared the order as void ab initio. Now the issue before the High Court the High Court of Kerala is whether the NCLT is empowered to declare an assessment order void ab initio under Section 33(5) of the IBC. So the decision of the High Court is follows. While determining the quantum of tax and other levies against the corporate debtor during the moratorium period under Section 14 of IBC, what it held was, after declaring moratorium, there is an embargo on enforcing the demand. But there is no embargo under Section 14 read with Section 33(5) for determining the quantum of tax and other levies. The court was very clear, you cannot enforce a demand, but that doesn't stop you from determining whether there is a demand or not. So those proceedings can continue. The second issue that was decided by the High Court was whether the NCLT has power under IBC to declare an assessment order void ab initio. So what the High Court felt is that the Company Law Tribunal does not have any power or authority under IBC to declare an assessment order void ab initio. So once this was determined, the act of NCLT declaring the order void ab initio could not be done, but this is the order of the Honorable Kerala High Court. We have to see if at all the case reaches the Honorable Supreme Court in this matter. Next, we will move on to the Customs Act. So under the Customs Act, we had one case for the Honorable Delhi High Court, Sri Metallics Limited versus Additional Director General, where they distinguish the Rainbow Papers judgment here again. So we have to again, as I said, examine each and every law. Section 142A of the Customs Act says that the dues to Customs Authority has a first charge in respect of liability under the Customs Act. As we know, Customs Act is effective from the year 1962, and what the court, Delhi High Court held, where there is a specific exemption provided under Section 142A of the Customs Act, which provides precedence of the IBC over Section 142A, Rainbow Papers judgment will not be applicable. So here again, it said there was a specific exemption to IBC under the Customs Act, and therefore the Rainbow Paper judgment will not be applicable in the case of the Customs Act as well. So it further went on to say, the High Court went on to say that the factual matrix in the Rainbow Paper judgment was different, given that it involved the filing of claim post the last date of submission of claim after the resolution plan was approved by the NCLT. However, in the Sri Metallics case, the statutory authorities never submitted a proof of claim. So having never submitted a proof of claim, you cannot claim the charge over the property. That is how the Honorable High Court distinguished it. There is one more case of Sundaresh Bhatt, liquidator of ABG Shipyard versus the Central Board of Indirect Taxes and Customs by the Honorable Supreme Court on the 26th of August 22. So in this, the corporate debtor ABG Shipyard was into the business of shipbuilding, and they had to regularly import materials for construction of the ships. Most of the materials were imported from China also. And some goods were stored in the custom bonded warehouses of Gujarat and some container freight stations in Maharashtra. In both these places, the corporate debtor was storing its goods that it had imported. On 2nd of August 2017, CIRP was initiated against the corporate debtor. And on the IRP taking over, he sought custody of the warehoused goods from CBDT. Now, CBDT issued 5 notices between 2019 and, that should be 7th April 2019, raising a total demand of about 15.8 crores for what was there in their bonded warehouses. That's the claim. They raised a demand, not a claim. Raised a demand. Now, subsequently, NCLT passed an order declaring liquidation and continuing of moratorium under Section 33(5) of IBC. Liquidator filed an application under Section 60, subsection 5 of the code, seeking direction against CBIDT and customs to release the warehoused goods. So for the first time on July 2019, the customs issued a notice to the CD again in Section 72(1) of the Customs Act for an amount of about 7,663 crores. NCLT allowed the application filed by the liquidator and directed the respondent to release the warehouse goods to the possession of the liquidator. Appeal was filed before the NCLAT. The NCLAT allowed the appeal where it directed the warehouse goods can be released or disposed of as per the applicable provisions of the Customs Act by the proper officer. So here they reversed the judgment of the Honorable NCLT and allowed the Customs Department to take and dispose of the items in the warehouse. So the liquidator filed a civil appeal before the Honorable Supreme Court. The Supreme Court framed two issues in this matter. The first one was whether the provisions of IBC would prevail over the Customs Act, and if so, to what extent. And second, whether the respondent, the authorities under the Customs Act, could claim title over the goods and issue notice to sell the goods in terms of the Customs Act when a liquidation process has been initiated. These were the two issues that were framed by the Honorable Supreme Court in this matter. So, the Supreme Court observed that from Section 142A of the Customs Act provides that the Customs Authority would have a first charge on the assets of the assessee under the Customs Act, except there is an exception in the provided in the 142A of the Act itself, which says cases under 529A of the Companies Act 1956, the Recovery of Debts Due to Banks and Financial Institutions Act of 1993, then the SURFACE Act of 2002 and IBC of 2016. So all these four acts were excluded from Section 142 capital A. So what it said, the court observed that such an exception created under the Customs Act is also acknowledged under Section 238 of the IBC, where overriding power is given to the IBC against any other law that is inconsistent to it. Another reason the court said for the IBC to prevail over the Customs Act was that IBC, being more recent statute, clearly overrides the Customs Act. And since the demand notice were issued subsequent to the initiation of the CIRP, the same requires determination of dues by a proper officer. And the Supreme Court held that demand notices seeking enforcement of customs dues to be violative of Section 14 or 33. Fine. As I said, assessments are possible, but demand notice cannot be issued during the moratorium period. So it's very clear. It says at best the respondent could only initiate assessment or reassessment of duties and other levies, but not transgress the boundary of moratorium and proceed to initiate recovery against the corporate debtor. So what was held by the NCLT was upheld. What was order given by NCLAT was rejected, and therefore the appeal survived. So the NCLAT held that the CD had abandoned the goods much before the insolvency process, and thereby the title of goods had passed to the Customs Authority. Appellant contended that CD had not lost the ownership of the goods. The respondent, by issuing notice under Section 72 and filing its claim with the liquidator, had admitted that the CD is the owner. So here the mistake, or rather the what the Customs Department had done was that by filing a claim and also issuing notice under 72, it has admitted that the title to the goods belongs to that of the corporate debtor and had not passed on to the Customs Authority as observed by the Honorable NCLAT.
What is the basis of when you say that CD abandoned? What is the rationale for that?
Sir, so when you have left the goods at the mercy of the custom bonded warehouses and not claimed it for years.
Okay, that is when I have not taken delivery of the goods from the customs warehouse.
From the warehouse.
So then you presume that it is abandoned.
Exactly. And therefore the title passes to the Customs Authority.
Okay, right. Okay.
So on the first issue that was framed by the Honorable Supreme Court as to whether the provisions of IBC would prevail over the Customs Act, and if so, to what extent, the court has concluded that IBC would prevail over the Customs Act once a moratorium is imposed in terms of either 14 or 33(5) of the IBC, as the case may be. And the respondent authority only has a limited jurisdiction to ascertain and determine the quantum of custom duties and other levies. It does not have the power to initiate recovery of dues by means of sale or confiscation as provided under the Customs Act. That is the issue number one that was decided by the Honorable Supreme Court. The second issue was whether the respondent would claim title over the goods and issue notice to sell the goods in terms of the Customs Act when the liquidation process has initiated. The court has answered it negative. Therefore, there is no right in the moratorium under 33(5) continues, and therefore the customs authorities cannot sell the goods. It would remain with the right to with the liquidator. So the next is on Vijay Kumar Garg, liquidator of lands with Harba Thermal Power Limited versus Deputy Commissioner of Customs Division 1 Nagpur. So here again, the CD was setting up a big power project and had to import a lot of materials from China. And the Ministry of Power here being a very important project, power project for India, they took special sanction from the ministry and allowed import of equipment at zero duty. But it was just subject to some condition that the CD should produce a bank guarantee and a fixed deposit for equivalent to the amount of duty payable. So they just had to give security that they will be importing these items, give a bank guarantee, and subsequently, once it has been imported, they would be able to take back their BGs and FDRs. So the liquidator, once the company went into liquidation, filed for the return of the bank guarantees and the fixed deposit receipts. And it was held that under moratorium, invocation of bank guarantees was allowed. So in case the CD did not fulfill its obligation to set up the power plant within the time limit prescribed by the ministry had a right to invoke the bank guarantee and also encash the fixed deposit receipt in its favor. So whether this could have been done during the moratorium period under CIRP, the Honorable NCLT felt it could be done. It allowed the invocation of the bank guarantees. So why it allowed, if you look at section 14, subsection 3, the provisions of subsection 1 will not apply to two cases where the moratorium provision will not apply. One, such transactions, agreements, or other arrangements as may be notified by the central government in consultation with any financial sector regulator or any other authority. And B, a surety in a contract of guarantee to a corporate debtor. Therefore, Section 14 has a specific exemption to a surety in case of a contract of guarantee, and therefore this appeal was dismissed by the Honorable NCLAT, distinguishing invocation of guarantee is possible, not covered under moratorium under Section 14. So we move on to one more Bombay High Court judgment. Jalgaon Janta Sahakari Bank versus Joint Commissioner of Sales Tax. This was an order passed in the 30th of August 2022. Here, basically, this is a proceeding against in the SARFAESI Act, where it was held that the dues of a secured creditor is and subject to proceedings under IBC would rank superior to the dues of the relevant department of the state government. So I'll just run you through the facts of this case. It's slightly different from what we have seen till now, because basically deals more with SARFAESI and the RDB Act rather than IBC. But first, the facts of the case as follows. So the batch of writ petitions were filed by various banks on the insertion of the chapter 4A in the SARFAESI Act. So what section the chapter 4A provided was the mandatory registration by secured creditors and other creditors under the CERSAI website. And also section 31B of the RDB Act was also amended to provide priority to the secured creditors. Now, the petitioner filed a petition seeking priority with respect to two flats which were mortgaged to it as a secured creditor over the sales tax authorities. So the state submitted that under section 26E of the SARFAESI Act, merely provides priority to secured creditors. It does not create a first charge in favor of the secured creditors. All secured creditors would be equally treated. So what the court did, the court noted both RDP Act and SURFACE Act provide the dues of the secured creditor will take precedence over debts, revenues, taxes, tax, and other payable not only to the state government and local authority but also to the central government. Therefore, all IBC, the RDB Act, and the SURFACE Act all provide for similar provisions now, priority to the secured creditors over the government debts. So the court observed these particular I have extracted, where it says without recourse having been taken to the procedure envisaged under the RDB Act for recovery of its dues and without there being a determination of its claim by the DRT to the effect that any sum due is payable to it, a secured creditor is not entitled to invoke the provisions of Section 31B of the RDB Act. So therefore, if you have to invoke the provisions of the RDB Act, then you will have to go before the DRT. DRT would have to determine that the sum is dueable and payable to the borrower, and therefore you will be able to entitled to recover the amount. And if the immovable property is shown to have been attached in accordance with the law prior to Chapter 4A of SURFACE being enforced, then attachment is followed by a proclamation according to law. That is, priority is accorded by Section 26E and 31B of the RB Act will not get attracted if it is prior to the amendment. Now, on the issue of treatment of statutory dues under the IBC, this is where the Honorable Bombay High Court comes to the IBC as well, where it refers to the Rainbow Papers judgment, which is decided on 6th September and has held if the resolution plan excludes statutory dues payable to the government, it cannot be said to be conformity with the provisions of IBC. Therefore, the Rainbow Paper judgment itself would apply only to IBC and not to SURFACE. Now there is Provident Fund. So under Provident Fund, there is always one confusion that we have. There is a claim by the department, there is a claim by the employee. Which one should the RP accept? So employees go on to the Provident Fund portal. They check whether the PF deducted from their account has been remitted by the corporate debtor. And in case it has not been remitted, what they do, they add that to their claim when they submit their claim, employees and workmen. Similarly, they do it for ESI, they do it for TDS. So when the corporate debtor goes into insolvency, the first thing they do is they deduct the PF and ESI from the salaries payable to the employees, they do not remit it to the income tax department or to the PF department. So when they do not remit it, the employee starts claiming it in his claim form, as well as the department also claims it in their claim form. So let us look at some of these cases under the Provident Fund law. So first is the 2018 NCLT Mumbai judgment, one of the earliest judgments in the against Provident Fund. Precision Fasteners Limited versus Employee Provident Fund Organization. So here they say in alignment with the provisions of the EPF Act of 1952, Section 36413 of IBC also provides that dues in respect of PF, pension fund, gratuity fund shall not be treated as part of the liquidation estate. And as long as it is not treated as a part of the liquidation asset, the provisions of the code will not be applicable for realization of such dues from the assets of the CD. So this is the first judgment which clarified that you will have to keep the PF amount, pension amount separate from that of the liquidation estate. It is not to be distributed to the under the waterfall mechanism, but to be paid in priority. Subsequently, there was an NSCLAT Delhi order on the 11th of March 2022 in the matter of Sikandar Singh Jamunwal versus Vinay Talwar. So it is in the matter of the CD Applied Electromagnetics Private Limited. Here they said that Section 36(4)(a) lists out the cases which are not covered in the liquidation estate assets and should not be used for recovery in liquidation. One of that is all the sums due to any workman or employee from the Provident Fund, Pension Fund, and Gratuity Fund. So what the NCLAT essentially did is it compared Section 17B of the PF Act with the provisions under the IBC. So we'll see Section 17B of the PF Act, which speaks about the liability in case of transfer of establishment. So where an employer in relation to an establishment transfers that establishment in whole or in part by sale, gift, lease, license, or any manner, the employer and the person to whom the establishment is so transferred shall be jointly and severally liable to pay the contribution. So here the law under the section 17B, what it conveys is that in case there is a transfer of establishment, however the transfer is whole or part or any mode, gift, lease or any other manner, two people are responsible, the employer and the person to whom it is being transferred. Both of them, it says, will be jointly and severally liable to pay the contribution and such other sums due from the employer under the provisions of this act. So such other sums here include, apart from contribution, it might include interest, penalty, damages, any other charges that are levied by the department. And it also goes on to say, so any sums due from the employer under the provision of this act, which is the PF Act, or the scheme or the pension scheme or insurance scheme, as the case may be, in respect of the period up to the date of such transfer. So if there is a transfer, both of them are jointly and severally liable, provided that the liability of the transferee shall be limited to the value of assets obtained by him by such transfer. So there is a limit given to the liability of the purchaser, which would be to the value of the asset that he has obtained by such transfer. Now, the NCLAT, when it compared the IBC and Section 17B of the PF Act, said that there is nothing conflicting between the PF Act and the IBC. And therefore, the overriding effect of IBC cannot be triggered. IBC overriding effect will be triggered only when there is a conflict with any of the existing laws. Here, since there is no conflict, the court concluded that the resolution applicant should pay the PF dues also. And it unilaterally amended the resolution plan to that extent that PF dues should be paid in priority. So we move on to one of the other landmark case in this, that is the Jet Airways Maintenance Engineers Welfare Association versus Ashish Chawar, RP of Jet Airways. This Honorable NCLAT judgment on the 21st of October 2022, which was subsequently upheld by the Supreme Court as well. So now here, what the NCLAT did, it saw some reflections in section 18F and in its explanation. So what does first section 18F of the IBC say? That the RP has to take control and custody of any asset over which the corporate debtor has ownership rights, as recorded in the balance sheet of the corporate debtor or with the information utility or depository of securities or any other registry that records the ownership of assets. So there is a wide range of responsibility cast on the IRP, where it says that you have to check the balance sheet, the corporate debtor. If any asset is there, you have to take control of that. Then you will check with the information utility, which will also provide a list of assets and the claims available. Then the depository of securities. So whether the company has any investments in demat material form. Then any other security that with any registry. If this is available, so it might be CERSA, it might be any other registry which has a record of the assets of the corporate debtor. All these would have to be checked and all the control and custody of all these assets would have to be taken over. So let me just read the last line again. Ownership of assets inclusive, what all it covers, assets over which the corporate debtor has ownership rights, which may be located in any foreign country, that also we have to take. Assets that may or may not be in the possession of the corporate debtor, the highlight should be on two. Tangible assets, whether movable or immovable. Intangible assets, including intellectual property, Securities including shares held in any subsidiary of the corporate debtor, financial instruments, insurance policies, assets subject to determination of ownership by a court of authority. So we have to take control over the asset which may or may not be in the possession of the corporate debtor. And then there is an explanation to section 18, which also the court observed in the Jet Airways case, which is that for the purpose of this section, assets shall not include the following. What it shall not include is A, assets owned by a third party in the possession of the corporate debtor, held under trust or any contractual arrangement, including bailment. So this may be in the case of if you are doing a job work, you might have a third party product with you for you to convert and return it back. So that will be an asset of a third party in the possession of the corporate debtor. This asset the IRP need not take control over. And the second is assets of any Indian or foreign subsidiary of the corporate debtor. So subsidiaries assets need not be taken over, just treated as an independent legal entity. And such other assets as may be notified by the central government in consultation with any financial sector regulator. Now, what does the NCLAT read in this? So what the NCLAT said, if the corporate debtor maintains a fund for the payment of a provident fund or a gratuity fund or any other retirement benefits to its workers and employees, that will be an asset. So if the corporate debtor has an in-house fund, it will be an asset of the company. But IRP is required to take control and custody of the asset over which corporate debtor has ownership rights. Now, when we look at the explanation to section 18.1, the assets comprising of provident fund, gratuity fund, pension fund belonging to the corporate debtor are assets which the employees and workmen have a right, although assets are in possession of the corporate debtor. Right? The gratuity fund, pension fund are essentially assets of the employees and the workmen. So therefore, those will not be taken control by the IRP even after initiation of the CIRP process. So we look at the conclusions of the Honorable NCLAT. First one, it said that the funds, that is the provident fund, pension fund, gratuity fund maintained by the corporate debtor, have to be utilized fully for the payment of the PF, pension fund, and gratuity fund of the workmen and employees. And these assets cannot be included in the information memorandum as the assets of the corporate debtor while inviting the resolution plans. Therefore, the RPs have to be careful to exclude these amounts specifically in the information memorandum and should not be shown as asset of the corporate debtor. Further, Jet Airways was depositing the PF deductions to EPFO. So therefore, Jet Airways was not maintaining an in-house pension fund for its employees. So the claim of a workman towards an employees towards provident fund should be towards the provident fund which is not deposited in the EPFO account. Further, they said that if you do not pay the provident fund or the employee or the gratuity, it will lead to violation of section 32E. And hence, to save the plan, the above payments have to be made. So Honorable NCLAT observed that the priority in the resolution plan should be payment to provident fund and gratuity fund. Now, apart from the payment of PF which has been deducted and the employer contribution that is due, there was also a discussion of whether interest on delayed payment, penalty, damages, all these are also part of the priority under the, which will stay outside the liquidation estate. Now, if we read para 118 and 119, the NCLAT has decided that interest on delayed payment of PF dues will also have to be paid. What it did is it cited the Supreme Court judgment in the Maharashtra State Cooperative Bank versus Assistant Provident Fund Commissioner in 2009, which says that any amount due from an employer appearing in subsection 2 of section 11 has to be interpreted keeping in view the object of the act and also the other provisions under section 11, 7A, 7Q, 14B, 15.2. It quoted various sections of the PF Act. And it said that the interest on delayed payment would be covered under the words any amount due from the employer. So what happens is the employer is liable to pay interest also damages also in case there is a default in payment to the fund. And if it is not paid within the stipulated time, the employer is required to pay interest, which is mentioned under 7 capital Q of the EPF Act.
I'm trying to connect with Deepa, ma'am. I think some connection issue is there. So,
I think we can take a break for 10 minutes or 10, 15
sure,
minutes.
sure. Let's take a break.
Sorry, just logged out by mistake. I'll just share the screen again.
Hello, madam. The institute has announced that there is a break for 10 minutes.
Yes, sir. We'll take the
So,
break, sir. Thank you.
yeah. Thank you.
So we will just continue where we left off. We'll proceed with the matters under the ESI. So ESI, I have pulled out one NCLT Ahmedabad order on 24th of November 2023. So in this, one of the prayers by the ESIC regional director was to include the ESI fund into the liquidation estate under section 36(4). So they wanted priority on par with the PF fund. And the liquidator also be directed to give priority of dues of ESI uh, on and give pari passu charge with that of the secured creditors for an amount payable of 71,000. And they also said that pending hearing and final disposal to condone the delay in lodging the claim. As per the order passed under 45A of the ESI Act, and they requested the NCLT to direct the liquidator to accept the claim of the ESI Corporation. Now, if you look at section 94 of the ESI Act, so the ESI Act says contribution, etc., due to the corporation to have priority over other debts. So, as in any government tax legislation, it said that there shall be deemed to be included among the debts which, under section 49 of the Presidency Towns Insolvency Act or 61 of the Provincial Insolvency Act or any other law relating to insolvency in force in the territories immediately before 1st November 1956. In the distribution of property of the insolvent or distribution of the assets of a company being wound up to be paid in priority to all other debts. So this is what section 94 of the ESI Act, and it says and any other amount payable under the Act, the liability whereof accrued before the date of order of adjudication of the insolvent or the date of winding up as the case may be. So as it is, ESI Act, the ESI Commissioner also claimed priority over all other debts as per section 94. Now, the Honorable NCLT held that insurance is a coverage of the premium paid, whether it is run by a private or a government, it offers a service. And the event is triggered only on the happening of some eventuality. And this cannot be equated to other benefits which are protected under the IBC. And it also went on to say that there is no provision under ESIC or for any charge or special status other than what is provided under section 45A. And therefore IBC which overrides all other laws. And the applicant also prayed for continuation of delay in lodging the claim. Here again, the NCLT amazingly usually is very, concerned and very liberal towards the government department. But here, the NCLT said that the applicant has not given any reason for filing the delay in the claim. And without any satisfactory reason, the delay cannot be condoned. So it also said that the claim of the applicant was not in time, it was not in the proper format, and therefore the tribunal does not deem fit for the to direct the liquidator to condone the delay. Now we will look at some on electricity dues. This is one case which was before the Honorable NCLT New Delhi and NCLT Kolkata, which was affirmed by the NCLAT. SBI versus Impex Metal and Ferroy Alloys Limited. So here again there was a successful auction purchaser under of the CD under liquidation, and he purchased it as a going concern. And after purchasing, he filed an application before NCLT Kolkata seeking a direction to the power distribution company to restore the electricity connection so that he can run the corporate debtor as a going concern itself. Now, the power distribution company contended that the new connection could be given only on payment of all the accrued dues. And they also said that a high tension agreement has to be entered with the CD, which is automatically terminated on the auction sale as concluded. So new agreement had to be entered into. And that would all be done only after the accrued dues are paid. Now, the successful auction purchaser had already made the necessary deposit for the high tension connection with the power distribution company. Now, the power company was directed to conclude the necessary documentation and provide the connection immediately. And for the past dues, it was ordered to file a claim with the liquidator, and it also further asked the liquidator to consider the dues and make payment as per section 53. And it also ordered that the electricity dues from the date of new connection will be paid by the CD. However, old dues would continue to be given under the waterfall mechanism. This clarity was given. Now, there are some more statutory claims that are there, which may not be exactly covered under any of the tax laws. But still, I found this one very interesting case in the case of the Municipal Corporation of Greater Mumbai versus Abhilash Lal. So I will just give you a brief background about this case. So this corporate data was called Seven Hills, and they were running two hospitals in one in Mumbai and one in Vizag when they went into CIRP. Now the hospital in Mumbai was by way of a land given by the Municipal Corporation of Greater Mumbai. So when the corporation plans the layout of any city, they allocate some place for the public distribution services, some for the hospital, some. So as a part of the layout, they have some allocation of land. Like that, the Municipal Corporation of Greater Mumbai allocated land to this corporate debtor to build a hospital. And this land was given by way of a lease, and it was subject to certain conditions, mainly that the land should be used only for the purpose of hospital. Now, the corporate debtor built the uh, hospital on this premises in Mumbai, but the lease date could not be completed, and there were certain defaults in meeting the conditions that were laid forth in the lease deed for the corporation. So, what the corporation did, it issued a show cause notice proposing to terminate the contract. Now, in the meantime, before the show cause notice could be issued, the corporate debtor was admitted into insolvency. And subsequently, they also found a resolution applicant. I think Dr. Shetty's medical center, new medical center. He was one of the resolution applicants whose resolution plan was also approved by the committee of creditors. After the approval of the plan, MCGM woke up and opposed the plan. They said they are a public authority, they are a planning authority, and there is an act called the Mumbai Municipal Corporation Act of 1888. And as per that act, the plan required approval of the improvement committee of the corporation before the resolution plan could have been approved. Therefore, they contended that without their approval, the said resolution plan could not have been approved by the committee of creditors. It was also argued that the show cause notice was issued prior to the insolvency commencement date, and they had already proposed to terminate the contract. Now, the resolution plan was approved by the adjudicating authority. They said a clean slate theory and as long as commercial wisdom of the COC, and therefore they upheld the resolution plan passed by the committee of creditors before NCLAT. NCLAT also approved the resolution plan submitted by Dr. Shetty's. Then it moved further on appeal before the Supreme Court. Supreme Court said it is not that the provisions of IBC that the Supreme Court has to primarily deal with here. It is the process adopted by the NCLT and NCLAT in overruling the MCGM's concerns. So they said essentially the land belonged to the Mumbai Corporation. So when the land belongs to a third party, how can the corporate debtor, by way of a resolution plan, sell away that particular property? And moreover, the plan also provided for encumbering this property and taking some loans. So they said you cannot even encumber a property owned by the corporation, especially when even the lease deed is not properly executed in favor of the corporate debtor. And when it does not fulfill the obligations under the contract, the MCGM has full rights to take away the assets of the corporate debtor. And what is important to note here is that the corporate restructuring by taking over the company was restructuring the company's liabilities by mortgaging the land, which directly affected the rights of the Mumbai Corporation. And the Mumbai Municipal Corporation prescribes for prior permission if the properties are being dealt with through leasing or through creating any other interest. Therefore, the said act cannot be ignored And since the resolution plan was never approved by the corporation, the proposal could not be, the resolution plan cannot be approved by the COC. They said if the COC wanted to approve the resolution plan, it should be in such a way that it did not result in encumbering the land belonging to MCGM. So then the argument provided by the CD and the resolution applicant were that provisions of IBC override all other laws. And therefore, once the NCLT has approved the plan, then it acquires primacy over all the legal provisions. Supreme Court observed that on the face of it, the argument has merit, but the Section 238 cannot override MCGM's right to control and regulate how its own properties are dealt with. So when the right exists with the Mumbai Municipal Corporation, it said IBC cannot override the right of another person to his own property. So this is what was the landmark judgment that was given under the Section 238 says that importance when the properties and assets of a debtor belong to it and not when it is of a third party. And therefore, it was held that in the absence of Mumbai Municipal Corporation's approval, the AA could not have overridden MGGM's objections and enabled creation of a new respect in aspects of properties and land. So this is one of the judgments which is not directly due to the government dues, but indirectly dealt with the property and the dues to the government. Now we will look at how you should treat government dues in a resolution plan. So first, we have already seen whether a resolution plan is binding on statutory authorities, even if the claim is not filed by them. We have seen that in all the other cases. Yes, it is binding, even if they have not filed the claim. Then they have said the payment to the OCs, including the government authority, should not be less than higher of the two. One is the amount to be paid to such creditors in the event of liquidation of the corporate debtor, or the amount which would have been paid if the amount was distributed in accordance with the resolution plan. So essentially, you arrive at the liquidation value, see how much the OC will get. You distribute the resolution plan value also in the same manner as Section 53, and you see how much the OCs will get. The higher of the two should be there in the resolution plan. That is one of the essential conditions. So generally, it is provided in the resolution plan how the payment would be made to the government departments and other operational creditors. And in case it is not paid, then the resolution plan will not satisfy the provisions of Section 30 and cannot be approved. Nowadays, there is one option where the resolution applicants leaves it to the discretion of the COC to allocate the resolution plan amount. But still, the COC has to allocate, keeping in mind the provisions of the code, and it should not be less than the liquidation value. In case there is no liquidation value payable to the OCs, then nothing need to be provided for the government dues as well. Then we spoke about the discrimination among class of creditors, whether in the same class of the OC class, there are statutory dues, there are dues to trade creditors. So all these come under the operational creditors, employees, workmen, whether you can discriminate among these class of creditors, whether you can provide different payment for each person. So the courts have clarified that different percentages can be given among different class of creditors. And of course, the clean slate theory was also upheld by the court, which said that once the resolution plan is approved, there can be no further claims. Now we will move on to one more landmark judgment in the case of a resolution plan. That is Committee of Creditors of SR Steel versus Satish Kumar Gupta and Lalit Kumar Jain versus Union of India. In both these matters before the Supreme Court, it was held that once a resolution plan is approved, it shall be binding on all the stakeholders. So this is to ensure that the successful resolution applicant starts running the business on a fresh slate. Also, we saw the Supreme Court order in Ghanshyam Mishra versus Edelweiss Asset Reconstruction Company, which said that on the date of approval of the resolution plan by the adjudicating authority, all claims which are not part of the resolution plan will stand extinguished. and no person will be entitled to initiate or continue any proceedings in respect to a claim which is not part of the resolution plan. So when someone successfully takes over a struggling company, they should not be surprised with unexpected claims later on. This is the only reason why it is said that there is a clean slate theory. This will only promote resolution applicants from applying and taking over distressed financial assets and, helping the corporate debtor remain as a going concern, failing which there will be an increased tendency for them to push them into liquidation, which is against the very provisions of the code. And we see one more case on Ultratech Natwarda Cement Limited versus Union of India, which is in the Rajasthan High Court on the 12th of July 2022. So here the application was filed by the CGST department seeking modification clarification of order dated 7/4/2020 passed by the court. And the department submitted that the relevant date to be considered for absolving the CD from its liability would be the date on which the resolution plan was submitted, which was in 2017, and the few liabilities which are generated after that date would remain alive. So essentially, what the department was claiming here is that the date to see the clean slate theory or to absolve the CD of all its liability would be the date of submission of the resolution plan by the resolution applicant and not the date of approval of the resolution plan by the corporate debtor. So the interim period, they sought to say that they had a right to claim that amount as well. So here the court, Rajasthan High Court clearly clarified that it should not be the liability should not be fixed as the date when the resolution plan was submitted, but it should be well settled in law that the relevant date would be the date of approval of the resolution plan by the NCLT and on the date on which he takes possession, and should not be the date when he submitted. Therefore, they said the order of the Rajasthan High Court did not suffer from any ambiguity and it was held to be correct and no need to modify the same. Now we look at one more aspect of contingent claims. So there are certain claims which are not determined. They are subject to some kind of litigation or some kind of determination by the department. So regulation 14 of the CARP regulations deals with what is the contingent claims. So it gives guidance on how you must treat these contingent claims. So it says when the amount claimed by the creditor is not precise due to any contingency or any other reason, the IRP or RP shall make the best estimate of the amount of claim based on the information available. So in case there are proceedings pending before any authority, the RP has to make a best estimate of what would be the liability and mention that in the information. It also says that the IRP and RP can revise the amounts of claims admitted, including the estimate of claims made under subregulation 1 as soon as practicable when further additional information warranting such revision comes to his knowledge. That is for the treatment of contingent claims. Now, in the matter of Tata Steel BSL Limited Varsha versus Varsha in the Bombay High Court, a 2019 order, the High Court allowed the admission of a claim of an OC which was pending dispute before the civil court. Now, the High Court clarified that the creditor cannot be denied the opportunity to have his claim added to the information memorandum merely because it was pending for dispute before the civil court. So accordingly, what the court did, it directed the IRP to include a sub judice claim at a notional value of 1 rupee. So this is what is suggested by the court itself. In case the RP is not able to determine the claim, he may assign a notional value of 1 rupee in the information memorandum. As soon as additional information is provided, he can include the same in the information memorandum. Now we come to the rights of the OCs. So OC is a member of the Committee of Creditors. Accordingly, they have the right to have the information memorandum, the RFRP, copy of the resolution plan, all of course subject to submission of undertaking, confidentiality undertaking. And when the value is available, the liquidation value also to understand what will be the chance of recovery post the submission of the resolution plan. Now, in liquidation, what happens? Start of fresh proceedings is again prohibited. However, if there are any continuing proceedings which have been kept pending due to the moratorium in CARP, those can be continued after liquidation order is passed. And in terms of regulation 45.3 read with Form H, the liquidator has to intimate all the statutory authorities. So regulation 45.3 only talks about Form H to be submitted by the liquidator for the NCLT. And in the Form H, there is a column which says the dates when the statutory authorities are intimated, like the income tax and the GST and other authorities. So it implies the liquidator would have to intimate all the statutory authorities immediately on commencement of liquidation. The government departments are expected to file their claim as an OC in the relevant form. And it is also clarified that in case they do not give a claim during liquidation, the same claim given at the time of CARP can be taken during liquidation as well. However, government departments should be educated to give their claim again because there might be an enhanced amount due to the effects of time. There might be some additional amounts which would have come to their notice or some kind of past assessments which should have happened and interest and delayed payments which they would have determined. So all these could be added and given as a claim in the liquidation stage. And all the assets of the CDs, if attached by government authorities against tax dues, they have to be released in favor of the liquidator. This may be in the form of a bank account, movable, immovable properties, all these which would have been earlier attached will have to be released in favor of the liquidator, and the tax authorities would have to fall under the waterfall mechanism under Section 53 and wait for distribution by the last, if the assets are realized and already adjusted towards tax dues, and then the same is not required to be reversed as the ownership of assets have already been transferred from the CD to the government or third parties. Now the stakeholders consultation committee. So the liquidator on commencement of liquidation has to constitute the stakeholders consultation committee within 60 days, days of the liquidation commencement date based on the list of stakeholders he has prepared. And the stakeholders consultation committee will form part of the OC also will be form part of the stakeholders consultation committee. One representative. So from the government department. What all matters now, it has been recently enhanced. This is just prior to the amendment. The remuneration of professionals appointed under Regulation 7, sale under Regulation 32, that is the manner of sale, pre-bid, reserve price, marketing strategy, auction process. Then the fees of the liquidator, valuation under sub-regulation 2 of Regulation 35. And then manner in which the proceedings in respect of the PUFE transaction shall be pursued after the closure of the liquidation proceedings. So all these matters will be decided by the stakeholders consultation committee. Though the recommendations of the committee is not binding on the liquidator, but still they will have an opportunity to participate and give their views. And the voting share in the stakeholders consultation committee will be in proportion to the admitted claim to the total claim. And only those creditors who have relinquished their security in favor of the liquidator will form part of the stakeholders committee. Those who have not will not form part of the consultation committee. And the liquidator will facilitate the stakeholders of each class to nominate their representative. So here under the government department has been given a specific class where they can nominate one person to represent them on the committee of the stakeholders consultation committee. And in case they fail to nominate, then they will be selected by the majority voting share of that class present and voting. So they said the one representative who is there on the consultation committee shall vote in proportion to the voting share of the stakeholders it represents. So consultation committee should advise a liquidator by vote of not less than 66% of the representatives of the consultation committee voting. And it, of course, is not binding on the liquidator. But however, if the liquidator is not following the recommendations of the consultation committee, he will have to report the same to the board and also to the NCLT in the progress report. Now, we move on to voluntary liquidation. So there has been a recent amendment in 31st of January 2024, where the regulation 3(1)A has been amended and sub-regulation 3 has been added. where it says a corporate person has made sufficient provision to meet the obligations arising on account of pending matters maintained under subclause 3 of clause B. So what is subclause 3 of clause B that has been added? It says the declaration of solvency shall be accompanied by a disclosure about pending proceedings or assessments before the statutory authorities and pending litigations in respect of the corporate person. So earlier, as far when we filed a voluntary liquidation, we used to see only what the liabilities were there in the balance sheet of the company and whether the company has sufficient assets to cover the liabilities, and accordingly declaration of solvency was given by the directors, on the basis of which voluntary liquidation was initiated. Now they have added one more clause. In case there are any pending matters before any of the statutory authorities, say for example, if the income tax assessment for the previous year is not yet over, earlier, what we used to do, as long as the tax dues were completely paid, we used to go ahead and apply for voluntary liquidation. Now we have to make a best assessment, and in case there is any pending assessment, it has to be disclosed in the declaration, and some provision would also have to be made in case there are any obligations that come out of the pending matters. So with this, I think we can conclude. So the BLRC report captures the rationale for subordinating the crown debts in favor of the recovering because of the recoveries of the banking sector which have to be made. So this is in interest of the business and the banks at large, so that the banks do not pass on the burden of increased interest and recovery cost by way of higher interest to the corporate debtors, rather to the companies. And one more very good aspect of this law is that all the discussion papers, amendments, everything is put up for public comments. Ample time is given to the professionals and to the public at large to look at the amendments proposed and give their suggestion. Post that, only the suggestions are implemented by the IBBI. And also that there are frequent changes made to IBC based on the various cases that have been before the honorable courts, and the feedback that is given and needs and market perspectives. So IBC is a very dynamic law. It has evolved to change depending on the needs of the sector, which is a very, very good factor. And that dynamism is required today for the economic environment. So though we may have to keep updating, I think we'll have to take it as in the interest of the public at large. So with this, I conclude my presentation. And if anybody has any queries, I would be happy to answer. I think with that, we can conclude the session. Thank you very much for all the patient hearing. And it's always a pleasure to address fellow professionals. May I request Anjali to please close the session?
Yes, ma'am. On behalf of participants and team ICICI IAB, I would like to extend my sincere thanks to ma'am for taking out time and addressing session on the topic treatment of government dues under IBC. Thank you very much, ma'am, for sharing your experience and learning with us. It is very interactive and insightful session with you. Looking forward to have more session with you. Thank you very much, ma'am. You are requested to please share your material with us.
Sure, I will do that. Okay, thank you very much.
Okay, ma'am.